Hello, everyone. My name is Alancay Morales. I am Indigenous Peoples Rights International's advocacy coordinator, and it's a pleasure for us to have you all here. And we're very excited about today's event. And for starting, I would like to introduce our global director, Ms. Joanne Carling.
Hi. Alancay, are you?
Yes, Joanne, for the welcoming remarks to today's event. And yes, thank you, Joanne.
Okay, so yeah, good day to everyone. For others, it may be afternoon, night, or evening, but you're all welcome to this event, which is the launch of the second digest on the laws and jurisprudence upholding the rights of indigenous peoples, and these are at the global, regional, and national levels. Let me again, welcome you all, including the speakers. We are very honored to have esteemed speakers who will be introduced later by Alancay. But just to let you know that they are involved in the advocacy work in relation to upholding the rights of indigenous peoples. Now, just an introduction, we call this the Xanharu, the digest, meaning path, which is an indigenous word from our brothers and sisters in Mexico. And Xanharu, meaning path, also symbolizes that the right that symbolizes the right direction for indigenous peoples to be treated with dignity and rights, and this pertains to the need for respecting and protecting the rights of indigenous peoples. The reason why IPRI, or the Indigenous Peoples Rights International, decided to gather or collect these laws and jurisprudence upholding indigenous peoples' rights is to demonstrate that the rights of indigenous peoples affirmed by the UN Declaration on the Rights of Indigenous Peoples is gaining more ground, and it's a living, how do you say, it's not an abstract or creation only by the UN, but in fact it affirms that it is being affirmed at different levels, because it is intrinsically part of the human rights body, the human rights instruments, and it is being upheld by human rights bodies from national, regional to global levels. Now, part of the reason why we're having this second digest being launched now is because we are celebrating the adoption, of the UN Declaration on the Rights of Indigenous Peoples last September 12, is it? I can't remember the exact date. Anyway, and in this context, we want to look into how those rights are now being recognized at different levels. It's been a long struggle for us to finally have our collective rights affirmed by the UN through the adoption of the UN Declaration on the Rights of Indigenous Peoples, or the UNDRIP, and the process of having it adopted is really a major milestone. But the challenge that we are facing until now is it actually making a difference on the ground? Is it actually making a difference to the lives of millions of indigenous peoples across the world? And we want this digest to send a positive note that indeed things are moving. It may be slow, but they are moving in the right direction. So to recall, the first digest was issued during the Permanent Forum on Indigenous Peoples in April. It contained 8 cases at the global level, 7 at the regional level, and 12 at the national level. And these are cases or and decisions of Supreme Courts or constitutional bodies at the national level. Then at the regional level, these are more the regional human rights bodies like the Inter-American Court, Inter-American Commission on Human Rights, and now also the African Commission on Human Rights. Many of the cases at the global are coming from treaty bodies, but they're not only limited to treaty bodies. There are also other key actors that are upholding indigenous people's rights. And one that will be presented today is, for example, coming from a body related to the World Bank. So I will not go through that because it's Fergus who will be presenting it. But just to mention that for the second digest, we have 3 cases at the global level, 2 at the regional, and 6 at the national level. So if we look at the data that we have so far on the decisions made in upholding the rights of indigenous peoples, there's increasing number that are coming from the national level. That means at the national level, things are also moving forward. The rights of indigenous peoples are increasingly now being recognized in national legislation or jurisprudence. And these decisions are on different dimensions or elements of the collective rights of indigenous peoples, from cultural rights, right to land, territories, and resources, right to free, prior, and informed consent. So it encompasses as I said, rights that are affirmed under the UN Declaration on the Rights of Indigenous Peoples. And finally, I wish to again mention that IPRI is very much honored to have esteemed speakers with us who will be sharing their experiences on how they have moved taken steps to have the rights of indigenous peoples affirmed also in different levels of legislation. So again, welcome to all of you, and I look forward to the discussions and conversation that we will have in our common aspiration to uphold the rights of indigenous peoples. Thank you. Back to you, Alankay.
Thank you, Joanne. And as Joanne mentioned, Fergus Mackay, he's the Senior Counsel for Indigenous Peoples Rights International and has been a lawyer that has supported indigenous peoples around the world for decades and litigating cases at different levels. Fergus is the main author or the author of the digest. So Fergus, you have the floor, and it's great to have you here today.
Many thanks, Alankay. Many thanks, Joanne, and good morning, at least where I am, to everybody. As Alankay said, I'm the person who primarily works on the digest, but the digest, of course, is the output of a lot of different people's work all over the world, not just within the UN and not just within its treaty bodies, but also at the regional level, the Inter-American Court, the African Court, the Inter-American Commission, African Commission. Hopefully one day the human rights body in Asia as well. And also numerous national courts, whether it's trial courts, whether it's the Supreme Court or other courts of appeal, all over the world. As someone who, as Alankay said, has been doing this a very long time, I remember when it was hard to find any case law at all dealing with a lot of issues. That's changed considerably Today, you could write books and books about the case law, and people do, and never run out of anything to write about. Most of it is positive, not all of it is. There's been some recent cases in particularly the United States Supreme Court that have been setbacks in some regards, right? But the digest focuses on the positive, primarily not to give people bad ideas, but to focus on the positive. So we have, as Joanne mentioned, 3 cases from the international level. 2 of them I would call groundbreaking, insofar as they are either the first of their kind or the first of their kind that gets into certain issues in a substantive way that hasn't been addressed before. One is through CEDAW, the Committee on the Elimination of Discrimination Against Women, which somewhat ironically was brought by a man who alleged that his children were suffering from the consequences of transgenerational discrimination because his Indigenous grandmother was basically declared non-Indigenous by the law of Canada, and that affected him, his parents, and his children, despite numerous changes in Canadian law. Why is that case groundbreaking? Well, it's the first time that CEDAW really has delved into Indigenous people's rights, Indigenous women's rights, and certainly this notion of transgenerational discrimination, at least that I'm aware of. And it's a very important case, and I think it signals a new awareness and a new way of thinking, at least in that committee, about Indigenous people's rights. So I think it's a very positive development. The second case is in the Committee on the Elimination of Racial Discrimination, and I see Yaku Perez is here, who is the person who brought that case. So I'm not going to get into detail with that because he'll talk about that himself. That case is also a really important case. It gets into how state and Indigenous legal systems coexist and how the state is required to recognize and give effect to decisions of those Indigenous legal systems. In this case, it was an Indigenous marriage that Ecuador refused to certify, and the committee held that to be racially discriminatory, in large part based upon norms derived from the declaration, even though they weren't explicit about it. The other case at the international level is in the Compliance Advisor Ombudsman of the International Finance Corporation, which is part of the World Bank Group. The IFC decision is important because it not only tracks a lot of the norms in the declaration, it does so explicitly in some regards. In particular, getting into free, prior, and informed consent and what that
Fergus, apologies, the interpreters are requesting if you can get a bit closer to the computer. Yeah, thank you.
Notes, but okay. So that decision is important because it's a World Bank Group decision, albeit we can argue about the definition of free, prior, and informed consent that they use there, but nonetheless, it is very much tracking the UN Declaration. I'm not going to go through all the other cases. I will say this, though. The importance of the digest for me is not only that it provides information, but it allows us to make assessments at a legal level and also an advocacy level about the impact of the declaration, both in national law and in international law, and what that means. The introduction to the digest quotes one of the reports of the expert mechanism on the rights of Indigenous peoples, which basically says, quote, many of the rights contained in the declaration are already guaranteed by major international human rights instruments and have been given significant normative strength, including through the work of the treaty bodies, regional and national courts, close quote. So the digest provides evidence of that simply because it directly quotes from and explains all these different decisions at the international, regional, and national level, including legislation that's being adopted, that does show that the declaration is having a significant impact at those levels, and conversely, that those decisions adopted by the treaty bodies, adopted by national courts and regional human rights commissions and tribunals, are giving additional strength to the legal status and weight of the declaration simply by endorsing, and in some cases, wholesale quoting from the declaration itself. That dynamic is something that's been observable even before the declaration was adopted, simply because a lot of those decisions actually related to what was finally in the declaration, and also the draft declaration until it was adopted was affecting decisions adopted by those bodies as well. So that sort of mutual reinforcement is still going on, and I would say perhaps even accelerating recently. And that's particularly observable in the UN treaty bodies. There have been some really important decisions coming from the UN treaty bodies lately, particularly the last 4 or 5 years, where the declaration is really a foundation for interpreting a number of rights in those binding human rights instruments. And the same thing is happening at the regional level as well. The one level I think that is missing, and that is reflected in the second version of the digest, in addition to the national, regional, and international levels, is at the level of Indigenous peoples themselves, the fourth level of legal system involved here. So in the Ecuador CERD case, where they're talking about the relationship between national law and the Indigenous legal system and the Indigenous legal authorities, they even get into how one needs to recognize the other. In the national section of this digest, there's a law adopted by an Indigenous nation in the US, in the United States of America, that is implementing the declaration at its level, at the tribal nation level, and is making the declaration the basis for tribal government policy, tribal government interactions with US federal and state governments, et cetera, et cetera. So I think that fourth level of legal system is critically important in there as well, and one that we should perhaps pay more attention to in some regards. But either way, the digest, I think, is well illustrating a number of very key points, not only about how rights are being interpreted and reinterpreted and reinforced through these different levels, but also about what the legal value of the declaration is. It's a misnomer to describe it as merely an aspirational instrument. It's far more than that, insofar as much of the declaration restates existing law. And I think that's a critical point that needs to be taken into account, and much more highlighted in advocacy as well as legal argumentation, particularly those of us who are bringing cases and arguing cases. Those points and how the declaration fits into the larger scheme of things, I think, not only require more attention, but really require more systematic and concerted attention across the board. I very much hope that the digest helps in that process, and that it becomes an important source of information for people, as well as a source of inspiration for others who are perhaps suffering with some of these same problems, and can see that other people have succeeded in these dealing with these problems through those type of arguments and through the use of the legal system. I'm going to stop there. I would say that the next version of the digest is going to have a number of other really important cases that are coming out sometime soon, particularly in the Inter-American Court of Human Rights. There's about 3 or 4 cases that should be coming out in the next couple of months. There's a couple of important cases going through the UN system that should also be coming out in a couple of months. And there's a whole slew of national level decisions that'll be coming out in the next couple of months. And all of those will be reflected in the digest. If anybody who's listening on here has a case that they are particularly fond of or think is particularly important, please pass them along, and we'll try to include them if possible. So I'll stop there and say thank you. And unfortunately, I have to take my kids to school, so I'm going to have to leave you all. But I hope you have a very good discussion. Thank you.
Thank you very much, Fergus, for this overview and also looking ahead of what we might be expecting in the upcoming edition of the digest. And I think something that you mentioned, that it's very and it sets the tone, and in part of the next discussion, is how the declaration is not an aspirational document, but rather it's the standard that's being implemented at the different levels. And we'll hear more about these cases in the next section. So we'll be discussing with our next speakers about some of these cases that we wanted to highlight, as well as having a commentary by the chair of the expert mechanism on the rights of Indigenous peoples. So I will be introducing each speaker as we go along. And I would like to just very quickly mention that if you hear a bell, it will be like 1 minute before the time is up. It's a very challenging thing to shorten the time in these discussions, given the depth and the relevance of these cases. But so if you hear a bell, it will be 1 minute before the time is up. And if you hear it again, it's when the time is up, just so that you can take into consideration for your remarks. So our first speaker is, Fergus also mentioned him, is Mr. Yaku Perez. Yaku Perez holds a PhD in law, and he is a political, environmental, water, and human rights leader and activist. He is a former presidential candidate in Ecuador, and has led various organizations such as Ecuarunari, the CAOI, which is the coordinator of indigenous organizations in the Andes. And he was also the prefect of the province of Azuay. He has published numerous books and advised cases before domestic and international courts. And he's the person that brought the case against CERT that Fergus referenced. So we have a starting point for the conversation with you, Dr. Perez, and it's that your case is emblematic in the sense that it recognizes numerous elements about the self-government of indigenous peoples, the customs of indigenous peoples, and how this should be recognized, and in part what Fergus was mentioning about that fourth level of indigenous decisions, and how this relate to the decisions by the state as well. So can you tell us about the case, and what were the main lessons and learned, and also looking forward, what are the challenges that may lie ahead? Thank you very much for joining us today. The floor is yours, Dr. Perez.
Buenos días.
Good morning. Good morning, dear brothers and sisters, from my heart. I will tell you about an emblematic case which sent an international precedent for indigenous peoples. It has to do with the Sawari Reimi, with ancestral marriage. And before this, I would like to give you some context. The colonizers thought that we were inferior to them. Actually, even when there was a great discussion in Valladolid, the priest, Sepúlveda, said that indigenous peoples do not have a soul. And Fray de las Casas was saying that they do have a soul, and that they need to be Christianized. And if they didn't have a soul, they could, of course, not have a law, authority, epistemologically, knowledge, nothing. They didn't realize that we were 110 million people here in the Americas, that there were peoples, that these were peoples which practice agroecology, agricultural ecology. And as a result, they managed to handle corn. They fused wild plants, which allowed all this knowledge allowed to be able to handle corn even before 10,000 years before Christ. They were astrologists as well, and that's why they recognized the Star of the South, the chacana that I have here in my neck. They knew very well the different scriptures, different ways of writing. They knew about neurosurgery, they knew about the sun, the moon, they knew about the stars, and they also knew legal philosophic institutions which had principles which are now recognized in our language as randi, giving. Life is as if it was a mirror. You receive what you get. What you give. And this is recognized in the Andean philosophy. So we knew all these things. And in Kundaquilla, on the 21st of August, 2013, after we met with Manuela, my partner, we got married under the indigenous jurisdiction next to the lakes of Quimsacocha in the south of Ecuador. And after the ceremony, after the ancestral ceremony, the ritual, we registered our marriage before indigenous authorities, which were even recognized at the national level. And up to that point, everything was fine. I was chosen to be president of Ecuador, where we defended indigenous people's rights, nature, water, everything. And we organized a demonstration from the south of Ecuador until here to the capital. It was on the 13th of August, 2015. The government, the state, welcomed us with gas and with some repression, and we were criminalized because of the social protest before, and this happened as well on this occasion. We were apprehended, we were beaten up. Manuel and I ended up in hospital, and not because of doing anything illegal. Manuela was a journalist, she was recording with her phone, and I was there with my saxophone because I am a musician, and we were promoting the protests. And both of us ended up in hospital, and Manuela was also arrested for a few days later, and then she was expelled from this country. Manuela is French Brazilian. She went back to her country, and from Brazil, she asked to the Ecuadorian chancellor to be able to get a family visa because we were married. And the Ecuadorian government told us not to do it. They told us to show the marriage certificate.
Intentamos inscribir en mi ciudad al sur del Ecuador, Cuenca, negaron. Intenté inscribir en la Dirección Nacional en Quito, negaron. Presenté un recurso de reposición, negado. Un recurso de apelación, negado. Un recurso de hecho, negado. Presenté una acción de protección ante la justicia ordinaria, negado. Presenté una apelación ante la Corte Provincial de Pichincha, Ecuador, negado. Negado por todas partes, con una visión ius positivista occidental, despreciando, discriminando a las autoridades indígenas, el derecho propio, el derecho consuetudinario. En esas circunstancias, cuando ya no teníamos nada, mi compañera no podía volver al país, expulsada, separados los dos por un Estado colonial, presentamos una...
We presented pseudo-file before the third, and it was a long path, but following the disposition of ILO Convention 169, it was clearly stated that the right of developing our own institutions that allow our voices and our social economic rights and institutions of indigenous people and being covered by United Nations Declaration on the Rights of Indigenous Peoples and developing with the possibility of developing our legal institutions. Also under the umbrella of the Inter-American Committee and sheltered by the CERD that states in Article 2 and Article 5 about the right of other civil rights, amongst others, the right to marriage and of choosing the consort. So once admitted by CERD, state was notified, the state answered, and it was a long way to go. But finally, in May of 2022, this year, sheltered by the legal text we were presenting after this long path, this odyssey, this situation was solved, disposing that the state should register our traditional customary marriage and give the visa for the family, conform to national law, a program of formation for all public servants in order to attend indigenous peoples, also to change this colonial positivistic law that doesn't allow it doesn't support the international regulations, accepts this kind of decisions of indigenous authorities. Fifth, develop, as I said, this training program and disseminate this presentation widely and translate it into the Quechua language. Perhaps the most important is here to underline that ancestral marriage has the right to be used as exactly at the same level and avoiding the monopoly of the state and the state authorities. Our traditional marriage has to be protected, and it allows to take out of the tutelage of the state this institution and give it back to indigenous authorities, so that it's them, these traditional authorities, that with their own right, in their own right, be able to celebrate these ceremonies that can be afterwards be registered, and also to allow the communities, indigenous peoples, be able to extend the visa for family protection and also the passports. In fact, we issued a Quechua passport following what other indigenous people in Northern America have done, where also these passports have been issued. And so it's something new in public law for indigenous peoples, because once the indigenous marriage is recognized, also indigenous divorce will be recognized, and also it may be registered in international indigenous constitution and all other titles, also the communities, organizations, because we have own institutions. We have the Ayu institution, that's a family, the community, the Yakta as we call it, the organization, this is Tandanaku. With all these institutions we have, and that are not recognized. It's also something that has to be taken into account, that if other legislations have been implemented in Canada, New Guinea, and so on. Yes, for instance, in Papua New Guinea, since 1963, indigenous people can also celebrate their marriage, but again, under this religious colonial umbrella, with these religious ideas of Western countries. In this case, it allows not only to celebrate marriage, but also somebody, like it is my case, with a woman, as in this case, who is not indigenous person, but has another nationality, as in this case of Manula. So the rights have to be used. Otherwise, it's just wet paper. Very often we see that legal texts have to be revised, and the rights have to be exerted. The rights that are not exerted are not anymore any rights. And that's why I think it is a very important milestone we have seen. Obviously, it's also something that is something personal, something that happened to me. So I mean, that's why I experienced it in a very special way. But I think it is clearly, it's a case, it's a first step that shows that it is possible to get closer to this challenge of exerting accepting the equality of customary rights, indigenous rights, so that colonialism, segregation, apartheid does not anymore exert its influence on us, on all of us. Thank you very much. Thank you. Thank you very much. Thank you for these reflections about all that is implied in what you say. And that, of course, one thing is important, what is important to see the importance of making an active use of rights, so that we can see with more the elements of this. Thank you very much.
I would like to introduce another speaker who has been involved in a rather emblematic case as well. Mr. Daniel Kobey, he's from the Ogiek people in Kenya. He has led the struggle for the protection of their lands and territories. And Daniel is also the executive director of the Ogiek Peoples Development Program. And the Ogiek, and including your role in there as well, have led this legal battle against the state of Kenya for the protection of your rights in the case of the Mau Ogiek. And we had initially the merits decision, which was, I believe, in 2017, and now this one is the reparations decision. And can you tell us about what your case was about, and what do you think are the main takeaways and the implications of this judgment, particularly in the African context, right? Because we don't have that many perhaps decisions and not as emblematic as this one. So to start, if we can know a bit more about the case, and I'll ring the bell as well when we're approaching the closing time. So the floor is yours, Daniel, and thanks for joining us today.
Thank you, Alan Kai, for this moment. I thought of making it, because there's a lot to be discussed after being in court for 20 years. And you want to tell me I speak in 10 minutes. I'll try my best to squeeze a lot of information. And one of the issues I will want to say is that Ogiek peoples are in Kenya. We are considered indigenous peoples. with 52,000 people as by 2019 census. And as one of the issues which we are discussing about is that the Ogiek community have been struggling for their land rights in Mau, in Kenya. And one of the greatest issues about the conflict between the government of Kenya and the Ogiek community as far as the ownership of Mau is concerned. And the issue has been the issue of ownership in terms of conservation and ownership. So the Ogiek community have been trying to find ways and means to establish their right. And in early 90s, they started thinking, now the next thing is, because our rights, land rights are not being respected, let us go to court. So they spent 12 years from 1997 to 2009, they were in Kenyan courts, and they didn't get, because many times we were unable to get our rights. You could go to court and then you are told the file is lost. You go to court, you are told the judge is not feeling well, or something happens. So it kept being postponed, and sometimes they say that we have not paid our lawyer to attend to court. So this kind of issue continued over the years until now. In 2009, they had given an eviction notice for 14 days to Ogiek to move and everybody to move in Mau, and we never had anywhere to go. So that is when I talked with some of my friends. Remember at that time they were doing a case in African Commission on Human and People's Rights at Banjul, Gambia. Then we said, let's put our case before the court. So before the commission. And it stayed in the commission from 2009. And then in 2012, the case was transferred to the African court. And then that time, all these, we have been asking for the restitution of our land rights in Mau, and also that to be recognized as an indigenous community in Kenya. And one of the issues which happened was that we realized that as we do this, the African Commission on Human and People's Rights discovered that there was mass violations, and they decided to transfer the case to the African Court on Human and People's Rights at Arusha, Tanzania. So the case dilly-dallied for some time until 2014. The hearing was done in Arusha, in Addis Ababa, Ethiopia. 26 of us went there, and we got cross-examined by the government, and then later on it also delayed because there was an issue that we needed to have a dialogue with the government, which we refused. But later on, everything else could not work. In 2017, 26 May 2017, the Kenyan government, the African court, ruled the case in favor of the Ogiek community, but withheld what we call the reparation. And in that case, we decided having a lot of issues going on. And as we were doing that, everybody was saying it is unfortunate. It was never common for any indigenous community in Africa to take their government to court. And in fact, our case is the first ever to be in the African court. And this alone has made this to be a landmark case. It is being used. We are now getting people all over coming to learn from us and a lot of the issues. And one of the things which I thought I could, anyway, I mean, I wanted to share, but it's okay. And one of the issues is that after that, we got also into reparation, where we had issues. And as we were doing all this, one of the greatest challenge we had was the fatigue the community was having. But we came up with a mechanism where we were having what we call feedback mechanism, where we have to report back to the community everything we are doing. And also we also realized that there was need to continue involving the youths and the women. The youths were very good now using the media and all that. And one other thing which I will wish to say is that Ogiek community, we use a lot of media coverage to be able to convey messages. And for this, later on, the issue of reparation was delayed. And the reason was that the government was choosing the cover-up of COVID-19. So it delayed all the way from 2018, 2019, 2020, until the 23rd of June 2022. That is when we got also a landmark ruling where it was ruling in favor of Ogiek. And one of the issues is that they say the land tenure system, which has been there for over almost 20 years, that is 8 years in the African Coast, 12 years in Kenya. And also they wanted that they stop the, what we call continued eviction, and then we get our land back. And also have they also gave a compensation of 158 million for the damages which happened amongst the community, and also to have the Ogiek declared an indigenous community. And right now what we are doing is that we have formed committees from what we call Ogiek Council of Elders, who are now preparing as far as implementation is concerned. Because previously the government had formed task forces. Those task forces have not borne fruits, and those task forces have not had the report published, despite using a lot of taxpayers' money. And right now, we have now come up with what we call committee of external experts who are helping the Ogiek, this form of lawyers, experts, in the implementation of this case. So we are now deciding as a community to use advocacy, lobbying strategies, even from the people who are watching today and who are listening to me, to find ways to push the government of Kenya to implement. Now that we have a new government, we hope things will work. We will push our way using every means to see that it is implemented, so that the community also can live like others. Now, and one other thing which came up with this ruling, and the reparation ruling, is that the community must be consulted. So this is the issue of FPIC, which we hope it will work. As we have seen now, we are now working closely. We are visiting offices, agencies, to see that the issue is being implemented. And we have gotten members from other countries, from DRC Congo, from Tanzania, visiting Ogiek to learn on this ruling, because this is the landmark ruling which has ever happened in Africa, and maybe the first ever. And we are getting a lot of international coverage sometime to be able to people to understand. But what is now missing is the real implementation. I think that is when now this case will become will make a meaning, because without that, we may not say we have done anything. So I know, let me see. So the key thing about us is getting what we call community land rights, because we want our territory as a community, not just land. We want our territory as a community, so that we can do all our cultural and traditional issues without any problem, because the ruling also gives a chance for our language, tradition, and cultures. So there's a lot, and I had shared with Alankai some of the links which can be shared for those who want to read the ruling, and it will be a chance for you also to ask questions. As I said, I know I cannot finish in this short time, and I want to say thank you very much. Thank you very much.
Thank you very much, Daniel, for this. And as Daniel was mentioning, I shared on the chat box the both rulings, the merits and the reparations judgment. So, and if there are any questions, please feel free to type them on the Q&A or on the chat box, and we'll make sure that we address this when we get to the Q&A part of the presentation. Thanks a lot for sharing this experience, Daniel. And as you're mentioning, it's a landmark case in the context of Africa, and how you're leading this process for sharing your experience with other indigenous peoples, and how they can uphold their rights and helping their struggle with defending their rights. So thank you very much. And now we have our next speaker, who is Miss or Dr. Beverly Jacobs. She's a member of the board of Indigenous Peoples Rights International, and she's the associate dean at the Faculty of Law at the University of Windsor. And she's a member also of the Six Nations of the Grand River Territory in Canada. She's done numerous she's writings and publications, and formerly she was also the president of the Native Women's Association of Canada. Ms. Jacobs, we heard from Fergus about the Matson v. Canada case, and it's a rather emblematic case in the sense that it addresses what Fergus was mentioning about this intergenerational discrimination, and there are some elements of gender as well that date back to previous generations. So it's something that we wanted to know more about your perspective as a lawyer, as an expert, as a leader, what the implications might be of this case, and your takeaways from the Matson v. Canada. And also, before we also included in this digest reference a congratulation to Michelle, and I hope I'm pronouncing well her name, but Bonsawin, that she was recently appointed as a justice to the Supreme Court of Canada. So it's the first Indigenous person to serve on the nation's highest court, as I understand.
Mhm.
So, Ms. Jacobs, the floor is yours.
Okay, thank you very much. I just want to introduce myself in my language. It just helps to ground me, and it's related to what I wanted to talk about. So, Scano Soquego, Giaso, Gowenki say, Ganyangihaga, Nyagwait, Shoutda, Haudenosaunee. So what I said to you was greetings of peace to all of you. I introduced myself. I come from a matrilineal society, being the Haudenosaunee Confederacy. And so, you know, I'm following our mothers. I'm from the Mohawk Nation and Bear Clan, and received my name as well. And my real name is Gowenkyuse, which means she's visiting. So this is relevant to the issue, the Matson case. So coming from a matriarchal society, which Matson also comes from, you know, coming from that matrilineal society, that our identity is transferred through our mothers. So that comes from our traditional laws, comes from our legal orders as Indigenous peoples. That's always how our identity is obtained through our mother's line. So just a little bit of history with respect to this case. When we have an invasion of colonial law like the Indian Act, so just the word itself is, you know, is very racist. It's one of the most racist and sexist pieces of legislation that exists in the world. So in order to erase us as a people, they established this piece of legislation to erase matriarchal societies, because the whole legislation itself is based on patriarchal, colonial, Victorian rules. So when it was established, they were already studying our people, and they actually studied my people, the Haudenosaunee Confederacy, because our women were the leaders and the decision makers, and in order to erase that, you know, their colonial laws, which were already established in their world, was based on patriarchy, based on the male head of the household. So that was enforced through the Indian Act system, the Indian Act legislation, and the system that exists today. And a big part of it is about control. So control about membership, control about registration, control even of the land. So the Indian Act was not just about membership or registration as a status Indian. It was about the takeover of land and resources, and putting us as Indigenous people into these little square boxes of reserve land. And so, and that was a way to move us out of move us out of the way of development, that we were still in the way of development. And it was an attack on Indigenous women, because if you attack Indigenous women, you attack our societies. And so so as a result of this, so the Indian Act, it was first enacted in 1876. Canada became Canada in 1867. So in its legislation, and its British North America Act, it allowed this piece of legislation to be enacted. There was already colonial implications upon our societies through their legislation. They wanted to enfranchise us. They wanted us to assimilate. They wanted to totally erase us. It also established the whole residential school system under the Indian Act, and impacting our children by forcing us into the residential school system, and forcing us to be white, to be colonial, to be not who we are. So that, you have to understand that history of that legislation and how it continues to this day. So it still exists, as this case identifies, that it impacts future generations. It impacts all genders under the Indian Act system. But specifically, right from the first Indian Act being the 1876. So in order to become an Indian, a status Indian, you were male. So the male head of the household. So if you were married to him or a child of him, you became a status Indian. And if a woman made a decision to marry out, so marry a non-status, and make that very specific, because there's an issue about the colonial borders as well. So in order to become a status Indian, or when women married out, they were no longer considered an Indian. So they were no longer allowed to situate themselves in their traditional territory. They could not own their own territory. They were forced into their husbands' homes. If they were white or non-Indigenous, they were forced into those territories, into the male household. And, I had identified that a long time ago as the first phase of missing Indigenous women, because we lost a lot of Indigenous women at that time, because they were forcefully displaced from their traditional territory and could not come home. They weren't allowed to be home. Their children were not allowed to come home. And so it caused generational trauma in the relationship to the land, because even talking about land is, Mother Earth and relationship of women to land and territory. So it had a real impact on our relationship to our lands and our territories and the generations afterwards. So in recognition of, all of the colonial impacts from the legislation itself, and being registered as a status Indian, it separated the understanding of who we are according to our tradition, according to our own membership identification of who we are. So from a matriarchal society, then being forced into a patriarchal, colonial, racist, sexist system. So that's the background of that. So the Indian Act comes into place, it impacts women, it impacts the registration of women. And so there were challenges along the way. So challenges in 1985. Actually, there was a case before that. This CEDAW case recognized the Loveless case, who brought her issue as well to the court, or to the international forum at that time. And that was in the early 70s, and it impacted all the way through Supreme Court of Canada decisions, which shifted and created this, what's called Bill C-31, that was supposed to eliminate sexual discrimination, but it caused more. It caused the worst internal conflicts, even in our communities, by blaming women for wanting to come back home. So these were some internal struggles that we also had as a result of the Indian Act system. So although it was supposed to eliminate sexual discrimination, like I said, it caused more, because it became a conflict amongst genders, between the men and the women, because there was this process, layers of registration called Section 6.1 and 6.2. It's a really complex, complicated legislation that they created. Government created that. And so if you had status, so if a woman regained her status, she didn't obtain, 6.1A status like her brother would have if he married a white woman. She would get 6.1C status, and her children would get 6.2 status. So it became this process of status, of even levels of status. And so when that created that whole, created a gender discrimination, there were further cases, further women, Sharon McIver being one of them, who also challenged the Indian Act registration system according to the matrilineal descent. But again, her case only allowed second generation cutoff. So with Matson bringing his case forward, also, as a child, a male child of a woman who lost her status, that it had also was a cutoff for his children. Again, that was the further and continued discrimination of that matriarchal membership within our own societies. And so his claim, at CEDAW, it is a really important case, and the fact that CEDAW had recognized that. They recognized the gender inequalities that continued, and recognized also that as Indigenous people, and recognizing even the UN Declaration on the Rights of Indigenous Peoples, that we have a right to determine our own membership and a right to determine who we are as Indigenous people, and identifying that. So I thought that was really important in this decision. And the fact that Canada tried to argue that there's no human right to be registered as Indigenous, when in fact, that's part of understanding who we are as Indigenous people. And like the committee said, that Indigenous people, we do have a fundamental right to be recognized, and as a self-identification under Article 9 of the UN Declaration on the Rights of Indigenous Peoples, that we have a right to belong to an Indigenous community according to our own traditions and customs. And that there's, part of understanding this is that the state needs to recognize that. And in Canada, it passed a piece of legislation about the Declaration on the Rights of Indigenous Peoples. So again, there is a process here in Canada where they say one thing and do another. That's been a continuous process that Canada continues to control Indigenous people and say things, you know, here nationally, and does another thing in its practice. So that is part of the struggle here in Canada with respect to this legislation. And so with the committee's decision
Ms.
in
Jacobs,
recognizing the
if you
amendments of
can wrap up
2011. Okay, I was just getting to that.
thanks.
And so basically what I wanted to say is that the impacts of the CEDA case recognize the complexities. It recognized the continued discrimination despite any of the amendments that Canada has made to the legislation. So I think it is a really important decision when it comes to the identification of who we are as Indigenous peoples living in this place called Canada. Thank you.
Thank you very much, Ms. Jacobs. And indeed, one of the issues that you mentioned on how this is a long-standing, like the roots of the discrimination that in this case date back to the late 19th century, and how up to date people are still facing the roots of that very calculated way of targeting Indigenous peoples through their women, and from this other Western patriarchal views. I think these developments I hope are helping you advance in the right direction, but there might be other underlying issues that still need to be addressed. So thank you very much for your sharing your commentary about this decision on the Matson v. Canada. Now we have our next speaker, Mr. Binota Moy Damay. He's the chair of the expert mechanism on the rights of Indigenous peoples. Mr. Damay has been working for over 20 years on issues related to Indigenous peoples' rights, and he's a member of the Juma Tripura from the Chittagong Hill tracts of Bangladesh. And Binota, we are seeing all these cases and developments, both from what we saw in the first digest that Joanne was providing us with an overview, and this one's on this case. And one of the mandates of the expert mechanism relates precisely to overseeing the implementation of the UN Declaration. And we see these cases that in a way affirm the standards of UNDRIP. So we wanted to know your impressions from the cases and so forth related to from your position as chair of the expert mechanism on the rights of Indigenous peoples. So welcome today, and the floor is yours.
Thank you, Alanke. From my place, I'd like to convey my regards to everyone. Good morning, good afternoon, good evening, wherever you are now at this moment. I'd like to convey. Thank you for inviting me and having to this discussion. And it's also a great honor and pleasure to be part of this panel, listening distinguished panel members, and also from the Joan Carling and Pargus about the digest. As you have access the view from the MDIP or my opinion about that, all the discussion definitely very rich, but let me start by sharing some of what we have done as MDIP. As you know, the mandate of MDIP is to implement, to advance the UN Declaration on the Rights of Indigenous Peoples on the ground, and also the country mandate we have at the national level by invitation, either from the member states or indigenous peoples. So before going there, I'd just like to share a few words, what I think, listening from all the distinguished panel members now. UNDRIP had a study about the UN declarations, its 10th anniversary, the good practices and challenges. What we had in this study that despite there are recognitions in some countries, some states, and adoption of the UN declaration as a part of the legislation or national constitution, but there still has a lot of challenge, and that because of the non-recognition issue, and also the disrespectful the UN, the UNDRIP provisions that has enshrined. And many examples, we know this political recognition issue by the states and international actors and protection of their environmental rights, their right to the land, territories, and resources, free from informed consent, and the protection of their cultural languages. So all these are challenges that are the findings we had in this 10th anniversary the study of the UNDRIP, still unfortunately very valid, that all those provisions, important provisions, are not respected to many countries. And now what do we see on the positive side? That there are a number of treaty bodies that Fargus has also mentioned, and panel member also discussed that taking of UNDRIP as a reference and also as a recognition for indigenous people's rights. There are examples, say, for the Committee of Human Rights about the Sami people rights in Finland, about their internal self-determination, how the Committee of Human Rights interpreted in line with the Article 1 of the International Convention on the Civil and Political Rights, that how the indigenous people's rights, some indigenous people's rights, should be respected. And also, if we see other development that at the regional human rights commissions, there are also mentions, one Inter-American Commission on Human Rights, and also the African Commissions of the People and People's Humans and People's Rights. That's the referring UNDRIP in their jurisprudence. But what we have also realized that those jurisprudence and the recommendations has not been implemented or has not been realized. So that's what we have seen. On the other side, we see national human rights institutions or other business companies or civil society organizations also referring very frequently to the respect of free, prior, and informed consent of indigenous peoples in their activities in the indigenous peoples' land and territories. That is based on the UNDRIP studies on the free, prior, informed consent. We noticed as an UNDRIP that there are many organizations, even intergovernmental bodies, they are taking into account the recommendations of the UNDRIP on the free, prior, and informed consents that to be followed in any activities taking place on indigenous people's land and territories. So those are few positive side. But there are also the challenges instead of having the positive side that, as I mentioned, what we have found in our 10 years anniversary of the UNDRIP adoption report, the good practices and challenges, that there are still a number of issues that has not been settled at the national level, even though they have integrated UNDRIP with their national constitution. Even they adopted legislation and regulations or policy to some extent. So what we doing this year from the UNDRIP side? This actually for the next year preparation also. While we are preparing a study about the militarizations in line with the UNDRIP, we are also considering to prepare a report about the mechanism, establishing affecting monitoring mechanisms to the national and regional level for the implementation of the declaration. That is because a few countries, they have a national action plans about the UNDRIP implementations, and a few countries also have in the process developing national action plan. Now, in terms of the full and effective participation for indigenous peoples, and also free, prior, and informed consent, and also for their engagement to this implementation process and the establishment of the effective mechanisms. So their voices are important. So therefore, we are trying to see in our report next year these effective monitoring mechanisms for the regional and national level in line with the promotion of the UNDRIP. So now I would like to also provide some of views from my point of view. UNDRIP adoption is a process that develops between the state and indigenous peoples through a good faith and trust. And now the 15 years of this adoption, we have not seen much progress, even though there are some progress. But if we see in general, the situation of indigenous peoples on the ground has not been advanced very much. And now through the country engagement of the emblematic, we have been trying to focus how best we can advance or implement UNDRIP at the national level. That's where we are also recommending for the national action plan through our country engagement. So what I like to share here as well, that if we could do, or if there are more open process or invitation for the country engagement for the advancement of UNDRIP at the national level, there will be another way of advancing UNDRIP at the national level, I will say. That's because UNDRIP has the mandate to focus very specific way of implementation. For example, if you want to invite UNDRIP for the country engagement, you can really focus what you want to get from the UNDRIP recommendations, or what is your expectation from the country engagement process. So if you want to see the autonomy or self-government, or the implementation of the free, prior, informed consent, or right to education, access to justice, whatever, we can see from that perspective that UNDRIP can provide with their expertise advice in line with the UN Declaration of the Rights of Indigenous Peoples. So this is one way of what UNDRIP can be part of that. And also, as you see, one thing that I was listening these 3 cases, all of this are so much relevant and in line with our UNDRIP. And also, you know that UNDRIP is also human rights. Now, how we can really take this issue as an advancement of human rights on the ground. One thing is we need to see how we can build a political consensus at the national level. That's my own view. We need, in order to advance indigenous people's rights at the domestic level, one thing is building a political consensus, but how we can build it. So this is the way how the UN bodies, expert bodies, or special procedures, other treaty bodies can be involved there. And there are also some good examples, as I have just shared, like in the case of the Sami people in Finland, and also the National Action Plan for the New Zealand, and in the coming days, the engagement with Canada, UNDRIP engagement with Canada for the implementation of the UNDRIP. So these all are in the queue. And now we also see that this kind of advancement, one is facilitating facilitating for the dialogue and negotiations between the state and indigenous peoples. So this is another way of actually the UNDRIP implementation we can do. So I'll not take much So what I'll just say that we need to do to build some kind of political consensus at the domestic level. We need to work for that because indigenous people issues is a political issue. And we need to really deliver or mobilize ourselves from the political perspective. So I will leave here and I'm happy to share more through Q&A if there is any questions you have. Thank you so much once again.
Thank you very much, Binota, for that overview, and also in terms of how people can engage with the expert mechanism to advance on the implementation. So just I think how resources such as this and these experiences can help share from different regions and cases and so forth in advancing that implementation of the UN Declaration. Thank you very much. And we now move to the Q&A and discussion. We have some questions that have already been answered on the Q&A, but there were a couple of raised that one is for Yaku Perez about how it's also in Mexico difficult to address this type of marriage rights. These are not recognized, and when they are, and then by not being legalized, they are taken as a I'm not sure how to translate the unión libre, like a civil, not a legal marriage in the sense that it's registered as such, but just that the partnership is recognized. So whether yeah, just the difficulties that there are in the Mexican context in relation to this. So Yaku, if you have any comments about this experience in Mexico, and perhaps how your experience in Ecuador could serve in some way helping such a situation in Mexico.
Bueno, no conozco en estricto senso la realidad.
Well, I don't know the reality of legislation in Mexico, but Mexico is one of the countries with the most indigenous percentage of population. And so it's a good moment, I think, to start to demand and to develop jurisprudence with the first peoples of this so huge state. And of course, first thing, there is international legislation. What we are now celebrating the 15th anniversary of UNDRIP, and that allows us to strengthen indigenous institutions in all the states that are part of the UN Declaration. And the Vienna Convention also says in this there's the constitution of the republic in the highest peak of this pyramid, of this Kelsen type pyramid, but human right is beyond, is higher than this triangle, this pyramid of the national legislation. Convention ILO 169 or convention about elimination of all kinds of racial discrimination, this third. All this allows the recognition, it gives underlines the validity of other legal institutions. And we have to remember that the legislation has said that colonialism is something to be condemned, and that any doctrine based on racist discrimination is legally absurd, scientifically false, morally condemnable, and unjust. And so it's a moment to act. And this resolution issued now, recently issued now in May of this year, of the CERT's committee, demands the state of Ecuador to recognize this traditional marriage, and that this family visa is issued. And so with this jurisprudence, with this case with this first milestone that we have here, we can also in Mexico, I think, not only in regards to traditional marriage, but also under indigenous registration and avoiding the umbrella position of the state. And it is also important, not only, it's also important for other things, also other lands and territories. And territories is not just a piece of land. A territory is the capacity of solving about the future of what is decided of the people who inhabit with the free, prior, informed consent, self determination, autonomy, and so on of peoples. And so I think it's possible to claim these rights to nature, the rights to the common goods, and all the other institutions that have been and still are very often invisibilized due to colonialism. But it's a moment to show all this. It's on to that's why we have this challenge also for our Mexican brothers. And if you want, you can just Google here in my case, Yaku and so on, and then you can access more detailed information. Thank you, Jaco. And something also was shared in this issue. We have also this reference to this link of the whole resolution of this case, of the case of Jaco and also all the others. So thank you very much, Jaco, for answering.
Daniel, there is another question for you, that given that undue delay of these cases, if it's necessary to also undertake or move to the streets in social mobilization, or what's the best way to accompany litigation with a social movement, given the undue delays in these cases? Would you like to address that?
I believe it was my question, right?
Yes, it's for you. Yes, that's right, Daniel.
Yeah, I couldn't get the first part of it. What I can say is that that is another step which can be considered. But for now, we have not exhausted every step with government. Remember, we got a reparation judgment on the 23rd of June, 2022. And in that particular period, again, we were on electioneering for the new government. We just got the new government on the 13th of September. So we are now considering other ways and means to try and lobby and with the government friends and the rest before we consider that, because you can only consider that when the government have refused to act. And again, we have also we've been writing letters to the ombudsman asking for the access to reports, which we have not received because there was a task force report which was done for almost 1.5 years, and that report has never been made public. Which was actually the government order that a task force to be formed for the implementation. That alone was showing a step. So right now we are also meeting other government because we have formed a committee of experts. People will help us, form of advocates, people who are well endowed with advocacy strategies, which is helping us as a community, together with the Council of Elders, the Council of Elders. We are working on this. But as you said, I think even some of the members of the community have been saying, I think we can move to the streets, but you know the consequences of that in some countries. It means some people will find it rough and all that. But we are not ignoring that, but we are putting it one of the strategies. Thank you very much.
Thank you very much, Daniel. There is a question regarding the possibility of submitting other cases. So we have shared the contact details of Joanne and Fergus, and the cases can be shared directly with them. And would any of the speakers but like to address the final question is that in the case of India, even if they may have a national action plan for indigenous peoples, that the UN Declaration is not fully implemented. So what could be the suggestions to advance in the implementation in this context?
Can I jump on there?
Yes, of course, Vinata, go ahead.
Well, I'm jumping on because I'm from the South Asia, so from Asia region, and also this is my own opinion, not as a member or chair or MD. Okay, so the response is, so far we know there is no national action plan from India about the implementations of the UNDRIP. And also there are challenges in a way that there is no government clear position about the recognition of indigenous peoples as the indigenous peoples they have. But if also we see another way around, all the existing structure at the state level, there are autonomous district council, there are also scheduled tribe rights, village council, all actually we see this is the element that we have in the UNDRIP, like Article 4, autonomy, self-government, all this nature are there, right? They can decide their own education system, culture, social economic life. So those autonomous district council actually given some extent of their rights, but they are not given as indigenous peoples. So in a way, actually, it is not recognized. So there is a no clear action plan in India case. And there are also some very good question I see, but I'm not responding now. There's one, but very much happy to share later if anything you want to from my side.
Thank you very much, Binota. And we are approaching actually the end of our lunch of the digest. So there are a couple of questions that perhaps we can follow up or invite we can follow up in writing or perhaps invite you to a next event where we hope that we can further address some of the issues that have been raised. And now I turn back to Joanne for the closing remarks of today's event.
Yeah. Okay. So thanks so much to all the speakers. I think their presentations clearly demonstrated that the recognition of indigenous peoples' rights is increasingly advancing in relation to our customary laws, in relation to land rights, and in relation to the recognition of our distinct identities as indigenous peoples. These are just a few of the cases in the digest, and I would encourage all of you to read the digest 1 and 2. And in the chat box, we have my colleague have shared the link, so you can easily access the digest. We have the first digest is available in English, Spanish, and French, and the second one at the moment is only in English, but we're rushing the translation in Spanish and French, so that will also be made available soon. We've also been requested to have the digest translated in other languages, and we wish we can do that, but we need resources to be able to do that. So we're trying our best, and perhaps we can also get some volunteers to do the translation so that we can reach out to more indigenous organizations, especially since many are still not aware of their rights and that their rights are now being upheld in different bodies at the national, regional, and global levels. And this, of course, is not enough. We need different actions and combination of different strategies. It's not enough, as we see in the case of the OGIEC, that the implementation is still a challenge. So we still need to work together to really push not only the laws, but also in practice, in making sure that these laws are actually implemented in order for indigenous peoples all over the world to exercise and enjoy our rights just like anyone else. As already stated, our rights is not considered as special rights. They are rights, our collective rights are our rights to correct the discrimination and social injustice that we are experiencing. And so we still need to work together to make this a reality for all. So again, thank you to all. Thank you to all the speakers again, and also thank you to the interpreters for helping us and assisting us, as well as to my colleagues at the Indigenous Peoples Rights International. I wish you all a good day, and again, encourage you to look into the digest as provided in the link. Thank you.